morning, welcome to this third video in the Corrupt Bailiffs series. Today I will be talking about what I will refer to as the 7-day letter and why this principle fails catastrophically. We've already shown that Experian records are incorrect in many cases. It's impossible to keep the records of 60 million people up to date, and subsequently when they release their data to these thugs, the thugs then decide which home they're going to attack. So the law clearly states, within bits and pieces of the GDPR and Finance Acts and what have you, which hopefully I will intercede with along this talk, that the debtor's identity must be kept away from anybody else, basically. So nobody is allowed to know the debtor is in debt, except for the bailiffs, the courts and the creditor. Okay, fair enough. But before they visit the target property, the situation is that the bailiff should ensure the 7-day letter is sent. But there's a problem with this, because the court procedures documents say it is simply adequate enough for these thugs to claim to have sent the letter. There are sufficient details on the internet to show this letter is never sent. And in the case of DCBL, in a separate court case, Yasmin Mir, their solicitor director, was told by the judge that the people who were bringing the case were not sufficiently wise within the law to understand the importance of that document. He was also satisfied that they had presented every single document they had. This 7-day letter was missing. The judge said to Yasmin Mir, legal director of DCBL, that while she was quoting the correct procedure to follow, she had no postal record of her sending the 7-day letter. Notwithstanding the requirement to send the letter under court procedures, the actual court procedures do not stipulate how a record of the dispatch of mail should be achieved. There is just a presumption that it will be delivered 2 to 3 days after it's dispatched. But therein lies the problem. This court procedure should include, for the sake of clarity, that it should be sent recorded. William Docker's 1680s London Penny Post also recorded details on letters accepted for onward transmission. The registration of letters as known today was introduced in 1841. There is no excuse that the courts were unaware of this, and this would have provided proof that the 7-day letter is being sent and received, and it would give the opportunity of the person on the doorstep to deny receipt and return to sender if the person who it was addressed to was not present or located in the property. Thus, the 80 minutes of terror would never have occurred if this court procedure was correctly written. The Postal Act of 2000 has a section called Service of Documents. Any document required or authorised by virtue of this Act to be served on any person may be served by delivering it to him or by leaving it at his proper address, or by sending it by post to him at that address. This would suggest that if a court order, i.e. a service of documents process, is going to be served on a debtor, the only address that letter can be sent is the same address as what is on the court order, because you cannot serve documents to an address other than the court documents. Thus, claiming to have sent a letter to my address when it was not the address on the court order means that they contravened the Postal Services Act by sending it to the wrong address. So, we're in a situation where a thug turns up at the gate claiming to have sent a 7-day letter which was never sent. Now, whether he personally knew it wasn't sent or not is a different matter, but the de facto matter is that if it had been sent, the occupant of a debt-free home receiving a letter for somebody else is not allowed to open it, so therefore they are not expecting a thug to arrive. So we are in a catch-22 situation for the thug who turns up, and that is, if the debtor receives a letter saying the bailiffs are turning up in 7 days, they can do all they need to remove property, etc. But on the other hand, if he's got the wrong house, and we are talking specifically about being at the wrong house with the wrong person with no court order, the person who receives the letter is not allowed to open it under the Postal Act. There is no debt, and because there is no court order on that property, the thug bailiff has no right of entry. Where do we go from here?